Just a minute, please. We wish to issue the following directions on how we are going to proceed. For good order and pursuant to Rule 17 of the Mtunga Rules, which empowers the court on its own motion to consolidate matters for expeditious disposal, the following petitions are hereby consolidated. Petition number E365 of 2024, Gachagua petition E013 of 2024, E014 of 2024, E015 of 2024, Nairobi petition E565 of 2024 shall be the lead file. All filings henceforth shall be made in the lead file. Pursuant to that consolidation, the parties shall appear as follows.
Okay, so the new order of appearance with respect to the parties will be as follows. HE, the Gachagua, as the first petitioner. The second will be Thomas Kimoto Maingi. I will be Honorable Jane Njeri Maina. The fourth will be Honorable David Munyi Madenge. Fifth will petitioner will be Grace Modoni Mwangi. Clement Mochiri Muriuki will be the sixth, and the seventh will be Edwin Munene Kariuki. The respondents will appear as follows. First, to the National Assembly as the first respondent. National Assembly, Kenya will be the fourth, and the Honorable AG will be the fifth. William Ruto, the president, Kindiki as the second interested party. Unless there's a party which is left out.
Yes, my lord, we are.
Is there anybody who has been left out on the quorum to amend consolidated petitions? Yes.
I was in petition 013 of 2024. I had not been notified, and therefore I learned of these proceedings on the Nation TV. Therefore, yes, I came all the way from Kirinyaga because notified. Once the file is forwarded before the chief stranded what is happening, and our petition is being mentioned. Therefore, we have had to rush very fast so that I can make it in the second session, the afternoon session. Therefore, I wish. Maybe perhaps we can.
Petition E13 and E14, Gachagua.
Yes, it was consolidated, and we were told that. However, we were not notified. I just learned of it today on the TV at 11. So we had to rush. And perhaps clarification purposes.
Is there anybody who has been left out?
Your information,
yes.
Just to draw to the court's attention, there is an application lodged United Democratic Alliance, which can be considered at an appropriate stage. Thank you, madam.
Interested party or interested party?
He's an intended. He has not been joined as yet.
And on the parties?
Yes.
In this petition, I'm assuming it's one of those that you have mentioned, 528 of 2020.
We have not mentioned that petition, and on that score, let me say this: that they mentioned different petitions which were not before us. I think we should be very clear that we can only deal. For us to mention any matter which is not before us and which has been placed before us, we shall make that communication. So I think we need to be very clear that jurisdiction is prescribed to particular files. Thank you very much.
My lords, your leadership, permit me to request that the E565, in which the deputy the petition, and E015, interested party. Let the record of this honorable court show that we were not given an opportunity to be heard on the issue of consolidation. Let the record, the court has acted of its own volition and the normal practice, even under the Mutunga rules, is to accord parties to state their views on a proposed consultation. This is the court ruling for an issue we were not asked to give up. Thank you.
Lordship.
Your Lordship, we have had the orders that have been granted by the court, consolidating the matters and creating another lead file. And that creates the problem we were trying to address in the morning, Your Lordships. That now this bench has created 2 lead files. We have 6 files that are before you, Your Lordships, with the lead file being E522. Which files are not before you? We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning. That if those other files were before you, this confusion will not be rising up.
Mr. Ndegwa, there's absolutely no confusion in these matters. Let us not bring confusions where there's none. I think in terms of consolidation, we have cited the rule under which we have acted, Rule 17 for avoidance of doubt of the Mutunga rules. I think we need to move forward.
My lords, on behalf of the respondents, we confirm that we are ready to move forward. I think too much time has already been taken on issues that two proposals. First, we would like, my lord, having read what has been arguments and facts, and I draw you to paragraph 5. They say that that Honorable Court recuse itself. It would be gravely serious to the respondents if they were allowed to prosecute this application. Take a second bite. We would like to argue both of them to allocating time. We are going to have another long approach. We are willing to say in advance that whatever time you give us, each we will accept. You directed, my lord, in the morning.
Yes.
Yes. But it is in that application that has been advocates. That is the application that seeks, on the one, the second hand, requires the recusal of this thing.
It is one application.
It is one application.
There are 3 applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes.
I just, my lordships and my neighbors, wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals, and 159(2)(b, justice shall not do petitions. And let us move forward. Thank you.
My Lord, the best that we could in terms of complying with those directions needs to be gagged on the issue of time. We protest. We shall require sufficient time, are as different as UDA can be from purposes of the difference. The application under Article 165, because we've had to include their earlier complaint in the morning.
Lord, I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right for it. My lords and my lady, take charge.
There is no, I'm responding to what has happened. Let us be fair to each other. And my Lord, what I'm saying is this, that for purposes of those under Article 165, because in the morning when we raise the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We do the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need grounds. We just need sufficient time to do our business. Issue number, then it would effectively mean, as my learned colleague Mr. Ngoya had indicated, were committed by the Deputy Chief Justice are okay. Then we shall now address authorities, because now we've been told a different instructions. When we came here, we thought that while we were let them prepare authorities to argue on the issue of recusal. When you are given so my Lord, we cannot be able to argue we cannot be able to argue as expected by our client. And there is no similarity to issues. Therefore, my lord, I urge you,
For recusal.
there are two applications.
Where are they?
At least I know, Gachagua, you mentioned one, which I believe yesterday, 21st of October. There is another.
Okay, Mr. Mugabe,
Yes,
these are the directions we are making. The application is the application. And perhaps, my lord, before you give the directions, with my learned friend, Ms. Kimoto, she was not aware of directions in the body that applications be, and we come back before you integrated in the E013. Therefore, either for recusal or for challenging the impanelment. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her similar application if she so wishes. Council, listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the course in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. Panelment. And then after that, we'll make a ruling for the way forward. So let us proceed. Let us be courteous to each other. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, Judge Muriba will give the final issue directions on time.
Okay, this is how we'll proceed. The applicant the applicants will have any party in support application will have 5 application, then will have 7 minutes each.
There could be parties who, for the good reasons given, do not have filed anything. But we also appraise ourselves for the fact that the issue before the court is an issue of law.
Is a subject of the court for him not to be. The application is made in E015 by my friends. I saw that 10 minutes. I would have said
you have 10 minutes. You have 10 minutes.
Thank you.
Yes, Doctor. Yes.
My Lord, I received the instructions.
Dr. Kamuna, we please not audible.
Oh, I'm sorry, I speak loud.
Yes, speak.
I received the instructions yesterday from Gachagua that I come and make an application that Gachagua would like to be enjoined to this matter. We all know Gachagua. We can't pretend that we don't know Gachagua. And we know the role Gachagua has constitutionality and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I have right as an elder at the bar for a number of things which I may not be able to say if I'm representing the judicial.
It's okay. We have done that.
Thank you very much. May I then comment on one small thing?
Yes, sir.
The country is in a crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. Tremendous respect, with tremendous respect, he allocated some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. Part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my able friend, Mr. Mwite, will only have 10 minutes, will have no 5 minutes.
Mr. Mwite asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
Why? Okay. I think
trouble to read this constitution of Kenya. I have taken the trouble to read the constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American
Dr. Kamuna, we made proposals and we gave them. Apparently, you are not satisfied. What is your version? What would you want us? You want to give everybody how much time?
Where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say.
Dr. Kamino, I ask you.
Yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
What I'm saying to you is my respect, my lord. Time in the civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr. Kamino.
Let Paul Winter be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mr. Jomo Kenyatta, kifua mbele na matako nyuma.
Okay.
My lord, maybe.
Where are we going?
My lord, maybe.
Where are we going with?
Maybe I can assist Dr. Kamino.
With respect, will you sit down? Kamino is talking. Will you sit down? I don't mind the matter what you're talking about. Will you sit down?
Dr. Kamino,
under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior counsel...
I will not sit down. We're not practicing all your still doing breastfeeding.
That is also true. So, my lords, I want them to say yes.
Don't give yourself
My lord, I want them to say yes.
Excuse me.
My lord,
Dr. Kamuna, finish what you are saying.
What I'm saying to you, my lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we hurrying for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when it comes to this.
I think they mean something, Dr. Kamina. They do mean something.
Something means something when it is you and you approve it. Yes, my lord, all that I'm saying to you, let people talk. Let people address you. Where are we going?
People will talk.
When the country is burning.
Dr. Kamino, you have made your point. Please.
Yes, thank you. Yes.
Professor.
We have a Chief Justice who has been removed.
My lord, I think those of us who are representing substantive respondents, we are all agreed that you have given orders that we will comply with. It would help if we informed Dr. Kamino. It is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application.
Dr. Kamino, I've heard what you've said. We'll stick to the time.
When we come to substantive matters, let people...
I agree with you.
My Lord, in view of that time allocation, and I thank my Lord confirms that. My Lord, the point I need to make, and I prepare for certain aspects of this application. My colleagues, Professor Ogada, tried. Please give Ms. Professor Ogada and Mr. 20 minutes to do anything. That will enable us to be able, I didn't get enough time, Mr. Legote. It is supported by the affidavit. It is supported by the affidavit. So Honorable David Muni Marenge. And for the record, and myself, the record indicates we act for everybody without drawing any distinctions, because that I wish to make regarding the issue of why are we everybody watching we seem to be following an unusual path. My Lord, there is one simply substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations. The petitioners are also here on account of the relevant, on account of the fact that the business that the framers of the to do it within 60 days somehow happened within 4 hours. And why we are here is that when petitions are filed, because 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My Lord, the way in which the law, and this is express positive law, requires that to be done is satisfied. Have these rights been violated or not? In all that are not academic, Article 23 of the Constitution that conservatory orders may be given. When this matter went before your brother judges, probably a sister also, in their wisdom, they directed this matter as such enormity that we need to preserve the subject matter. That subject matter, my Lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces it. But my Lord, we are a heated discussion. We are here and we are having a heated discussion. What is the clear intendment of the Constitution is being circumvented, so that's to ensure that the subject matter is not preserved. My Lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, leave those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my Lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the application. So that, my Lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my Lord, and there are a lot of matters that directions must be given. So that, my Lord, that context would be absolutely important, because when all is said and done, the right to fair hearing and human dignity cannot be violated even during an emergency. My Lord, that being the background, we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court is express law. Having said that, my Lord, yes, the prayers are like this, and we are already about 6 substantive prayers. The linchpin of these substantive prayers, my Lord, is the fact that the Deputy Chief Justice, under Article 165, does not have the power to appoint or assign, as the words used by the Constitution, members of a certain court to hear the matters. My Lord, Article 165(4) is very clear. Where the Constitution says the President and Article 149 can nominate Kindiki, there is no argument that is made that a minister or somebody else can be made. We expect that there can be no feasible argument where the Constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empower this honorable court to make a finding that unless separated or amended to give the Chief Justice, the Deputy Chief Justice, express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place vests in the people. Judicial power by express words of the Constitution or to do this appointment and to act under Article 165 was vested on the Chief Justice. It is not by accident. It is by the express intention. So that, my lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madho versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my lord, all these cases we are aware of. So that, my lord, as far as Article 165 is concerned, we submit that that is not possible. But, my lord, this argument is developed a little bit further by the petitioners' applicants. Because the petitioners' applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do 2 things. 1, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. But those are irregular, because as we are saying, when this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, agreed. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the Constitution and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make emergency, what has so far happened, but something that would amount to violations of the Constitution and something that would amount to violations of the Penal Code as far as the issue of serving justice is concerned. My lord, for argument's sake, we proceed to an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these judges of the High Court from various stations had for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday. Have gotten their applications because from the standpoint of the petitioner, to set aside the conservative, it means anything. The multiple violations of the constitutions that are already ingrained and embodied in the various stop, a respondent and a government and its appendage. Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter long. There has to be satisfaction. If the Chief Justice, and she's a party in this application, and the government of Kenya, and leave the petitioners the first right of hearing under our constitution. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer the allegations. Such conduct in the normal sense of things. We went through the removal of the right to be heard, and judges were shown the door home. But my Lord, here it is assistable to speak for themselves. We are, as long as the bench has been appointed, appointment of the various judges to see, there cannot be a violence in various matters. But my Lord, I'm happy, if not 3/4, that you have been in service of the violations of the Constitution. My Lord, that may not have happened, but that is the only way reasonable people must be viewed. My Lord, there are certain authorities, my learned colleagues will go through them, but some time back, probably in the Okiya Mtata case, my learned colleague will clarify. The Constitution or statute says so and so of statutory have always issued. It shouldn't be different in this particular matter. I believe it is, and the decision in that decision was a technology, and accordingly, the Chief Justice, the CJ does not have authority under the Constitution. This is something that she could have done. Important question, because it is the job of the Chief Justice for the Deputy Chief Justice who has usurped. It is the basis for abdication, the Chief Justice not to do their job. The other case of
a few issues which are legal. I'll move from Article 1 of the judiciary. It has clearly provided, Your Lordship, that the people of, in this case, the power under Article 1 justice. Your Lordship, in administrative law, it's not known to the petitioners under what circumstances may have delegated these powers to the Deputy Chief Justice. Under Article 165, Clause 4 are not capable of being. Judicial power is derived from the people, exercised by the courts and tribunals established by this article. Again, clearly indicates that this power under Article 165, Clause 4 is not capable. Your Lordship, I invite you to look at Article 260 of the Constitution. It provides if a function has been created to be executed by a particular organ, it cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint, also violated the rights of the petitioners to be heard. And of this, the bench, and failed to note in petition number 14, it tells Your Lordship that the reason for which it was done was so as to meet the objective of setting aside the orders that were granted. It is important that you pay serious attention to paragraph 12 of the affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. circumstances the Chief Justice, the Deputy Chief Justice, authorize you to sit on a submissions that Article 10 has only arrogated that function again exclusively to the Chief Justice. Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday Mtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance. It has given the circumstances under which the Deputy Chief Justice can act in the absence out of office. The question of leave to which we are submitting without knowledge when the Deputy Chief Justice can exercise Chief Justice. Finally, Your Lordship, all these averments contained in our affidavits, the grounds of opposition, to which they shall bring to your attention the case of the grounds contained in our affidavit, Your Lordship, are uncontroverted.
May we request counsel? He's probably the most history of Kenya, so we don't know which of his many cases you refer to.
I will certainly be addressing my senior at the bar today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya as a transformative constitution. In the BBI case, David, Ndee, and others, it is a constitution of a transformative character, induces large-scale social character and conduct of politics. That the Constitution bears an internal discerning that is done of theory is Article 259 of the Constitution. That the Constitution has provided for its own theory to protect the character of this Constitution as a transformative charter. And in the grounds of opposition, they raise a case, Lorna Taylor and others versus the Chief Justice. That was the grounds of opposition by their. And in that case, this High Court said that the power performed by the Deputy Chief Justice in certain limited circumstances, those limited circumstances have to be demonstrable. That is versus JSC and another petition, E408-2020. I believe that is what Professor Gideon Muge was asking about. Paragraph 2938, constitutional authority, said that cannot be delegated by the Chief Justice because the Chief Justice does not cease to be a state officer. Another authority here, petition 31 of 2013, 14 EKLR, at paragraph 37. This case at paragraph 37 says this, that the Chief Justice under Article 165(4), I'll invite the court to really look at the express to a specific office must be performed by that specific officer. That is Article 259(3)(a). I'll run this the case of Karisa Chengo, whereby the office of Judge Justice, the person, and the office of Chief Justice are synonymous. Any responsibility to the Deputy Chief Justice, assuming that was possible, bear authorizing the DCJ to act as, ladies and gentlemen, Honorable of Ulysses, the coxswain was asked to block his ears using wax. That story echoes well for you today. There's a lot of heat and rancor But for you, as the court, an apex court under the Constitution, you as...
My lords, my ladies, I stand here to argue the supporting arguments. Point. Of purposes of our first is Article 141, Clause 1 of the Constitution. Article 141 that the swearing in of the president-elect shall be in public, the deputy chief justice. It's very clear. Says who must do and what will happen in the eyes of that person. Of the Constitution provides, and I quote, the swearing in of the deputy chief justice and in public. Another very clear stipulation. Then we go to Article 165, Clause 4. I want to emphasize one thing, my lord, my lady. Before Article 165, clause of the Constitution were aware of what would happen in the absence 48, Clause 4. Let us see what they said at Article 165, Clause 4. That any matter certified by the court as raising a substantial an even number of judges, being not less than 3, assigned by the Chief Justice. Full stop. For my mentor, Professor Gidu Muigai, wrote many years ago, called Political Jurisprudence Principles. Another look at the problem of constitutional interpretation. Decisions of constitutional courts must be formulable I'll not read these names in full, but you now know that if we approach this court and read for it Lena Conchella, the decision already alluded to, it will appear that this court's position is this power by the Chief Justice is administrative. If we approach this court and read the case of Kemri and the case of Omtata, both of which have been referred to by my learned colleague Mr. Gada, you'll notice that the power under Article 165 is not administrative. The court says so, and my Lord Judge Murima, you contribute that jurisprudence. It is a constitutional imperative. I think my teacher, Professor Gidu Mega, will frown at that in jurisprudence as being political jurisprudence, because then we cannot answer first-year law student coherently. Is it administrative or is it not? We will find it difficult to answer it. Fortunately for you, as judges sitting here, you are not bound by those previous decisions, and you must come to the correct interpretation of the law in a manner that would address similar cases in the future coherently and without subjecting the judiciary to possible embarrassment. So then you will have to go and read what the two cases say, Kemri and Omtata, constitutional imperative, and what Conchella says, administrative. But then you look at the eventual verdict in Conchella, even when they say it's administrative, they set out the preconditions for that. And the question you want to answer is this, my lords: have those preconditions even been met, assuming even that you take it by administrative, for the Deputy Chief Justice to take up the tools of constituting a bench? Because that's a limited question that we are here to address and to guide this court. I make an argument that none of those grounds has been met. For example, we sat in this court in the morning, and I know this question will arise subsequently when we did with the application for recusal, where my lord said, in the virtual system, we can sit on anywhere. We might wrong, it's not for any intention. We can sit at any time. We can sit from anywhere. We can sit on any day. Chief Justice, for example, be virtually absent, is it possible that the Chief Justice of Kenya distinguishes herself as the first person to be absent virtually? Whatever she is, at home, in Europe, in Asia, be absent virtually. The answer is an emphatic no. That in the is the Chief Justice disabled? At least the Chief Justice is disabled. And therefore, even looking at the administrative has been met, in which case the Deputy Chief Justice has to constitute this bench. Because I kept asking myself this morning, I would have been a judge, maybe one day I would be, maybe not, how uncomfortable it would be to sit as a judge when you perceive that some of the parties beat you. It must be a very frustrating situation to find oneself in, and my sympathies go toward judges who find themselves in those circumstances. Just one minute of this argument. But the interface between litigants and the judiciary in this in the e-filing system that we are interacting with, none whatsoever. Is the judiciary sequential move as taking up the powers vested expressly in the Chief Justice by lodging it in the CTS for us to interact with? Number two, provide reasons. We ought to have seen a decision saying, for the following reasons I take up this role of the Chief Justice, then proceed to give directions. In the absence of that step, my lord, you have stood up as individual judges, as some of the greatest defenders of our Constitution. That character you have established in the past demands that you look at the Deputy Chief Justice in the eye and say, you fell short of the constitutional standard, and therefore by virtue of Article 2 of the Constitution, what you did was null and void. Our seating, the three of us at this bench, is null and void. We must down our tools at that juncture. Allow me to invite my senior colleague, Senior Counsel Paul Mwite, to carry forward and
to be very brief, my lords, your leadership. Of the court file 015 from Kirinyaga Court in the middle of the night was a gross irregularity that impacts on a fair trial. The bringing of that file in the middle of the night from Kerugoya, presumably the Deputy Chief Justice, was another gross irregularity. For the Deputy Chief Justice to have sat in the middle of the night on Friday, the 18th of October, was a gross irregularity. The absence of communication from the Office of the Deputy Chief Justice to the parties, 015, was a gross irregularity. For your lordships and your leadership to have sat as a court outside the prescribed court days on a Saturday was a gross irregularity. The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemable. And I would ask that in respect to Article 50, we do not even go into issues of recusal. You are not sheep, your leadership should. On the basis of those irregularities. Down here. There is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday of this week. So now, with this litany of irregularity, this honorable bench found time to give a hearing today when they say they are only available. But justice is seen to be done. The only agency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petition. Was very weighty issue in order to swear in somebody somewhere. Yes, you are concerned with institutions. Permit me to point out with a lot of respect, my lord, to your leadership. I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea is that you preserve constitutionalism, you preserve the dignity of this court, because the people of Kenya are looking up to the judiciary. Preserve that.
May it please you, presiding judge and members of your court, we thank you for the opportunity to reply as respondents. Before I do that, I want to thank the judge.
To find out whether we are with the all meter or not.
Yes, how many people are supporting the application?
In number 15 we are.
I'm also in the petition 13.
Are you parties in this matter?
Yes, we are consolidated. So there's a petitioner, the second petition. Who was for the second petitioner, with support of the application. This is Kemoto Teresia Wanjiro from Test Kemoto and Company Advocates. For the second petitioner. Yes. So perhaps I'm not allowed to submit or go to. Okay, thank you. So we are in support of the application, and the fact of the matter and why we are in support of it is, number one, as I said earlier, we were never served with those directions. And the fact that we were never served, this is proper procedure. That's any matter that is taken before a judge. All parties must be notified. We were never notified. So why we were never notified, and I had to learn about this issue today, I do not know. That raises eyebrows. And from the petitioner's side of view is, will this bench be impartial? Or will it will be hard? Because if directions are being taken, petition E013 of 2024 is part and parcel. In fact, it was consolidated. We have not been notified. Why? Number two, for fair hearing, Article 50, has been repeated over and over again. Isn't this a violation of the second petitioner's right to fair hearing? In fact, some of these applications, I'm getting them now. Yet, I should have been served before. Why the hurry? Why the rush? Why am I supposed to be served right now in court and I'm told 5 minutes submit? What is in stake? Let us all get a fair hearing. And with these preliminaries that are coming up, one is meant to wonder, will we really get justice? Petition E013, 2024 was filed before petition E014. And
so just for your information, those were your orders where the petitions were consolidated. So that must have been your application before. So don't bring it here.
Yes, but the issue is, even after it was brought here, it is being mentioned and we are not aware. So if a matter is going to be mentioned and we are not aware, then it only shows either the bench is ignoring us, or perhaps our petition has no merit, and why so, yet we have not submitted. Let us be given a chance, let us be given audience, even to reply to the issues that are being brought forward. And we cannot reply when standing right now. I need time, I need 1 hour, or 30 minutes, or whatever, but I need time. So those are the issues why we are in support of this application. We feel that we are not being given a fair hearing. And the other issue that has been raised also, that the bench sat on a Saturday. We are not aware, we are learning right now. We know court operates Mondays to Friday, 8 a.m. to 5 p.m. This Saturday, when was this direction issued? Why were we not informed? So those are the bases why we are now joining hands. Though our petition has its own grounds, but then again, because of those issues, we feel if we don't raise this issue, then we might not get proper justice, because there are some people who, of course, are SDAs who are not able to sit on Saturday, who are not notified again, you know, those kind of issues. That's why we are wondering why the rush. Yes, maybe...
We are on the application for empanelment.
Yes. Yes. That is the issue. The issue was that, and I've also talked about it, we were never informed. And any petition, any case that will be given direction, so long as I'm late, so long as there's a petitioner there, I have to be heard. And that is the law. And there's nothing new I'm saying. This is why is it that I'm being ignored? I'm being notified 11 a.m. watching television, and I was very eager like any normal Kenyan. I see my petition being mentioned. I was very angry, but I decided to take a vehicle from Kirinyaga County quickly to come before this court and inform the court that that is not fair. That is not fair, and Article 50 has been violated. And this being a constitutional court, kindly allow us to participate. Yes.
Your Lordship, in the limited time that we start, your name please. My name is within the limited time that we start with my learned friend, Mrs. Kimoto, and despite all those challenges, we have come up with about 4 points which we request that we be allowed to submit on, since we may not have more time to file documents in support of the application.
So kindly, my Lord, give me 5 minutes. Your Lordship, the powers that are given to the Chief Justice to empanel a bench, as submitted by my learned friends, is not a power that can be delegated. In constitutional classes, which we have the privilege to be tutored by senior counsel, Professor Gachagua, he told us that there's a principle called delegatus non potest delegare. A delegate cannot delegate. So that the people of Kenya have delegated power to the Chief Justice to exercise that power. And the Constitution does not leave any room for delegation of that power. So now, having been empaneled by a person who does not enjoy the people's power to empanel a bench. My Lord, this is a jurisdictional question rather than an administrative question. And from the decisions which have been cited by my learned friends, Kemri, Okiom Tata, and the Conchela case, one thing you learn is that in Kemri and Okiom Tata, the court said this is a constitutional function and it cannot be delegated. When you go to the Conchela case, the court allowed or said that the Deputy Chief Justice could empanel a bench. Again, it went ahead and gave some conditions. I don't want to go through all that. But Your Lordship, what you learn again is that shortly after the Conchela decision was made, an appeal was filed in the Court of Appeal. And who filed the appeal? It is the National Assembly, who is a respondent today. It is the Senate, again, who is a respondent today, urging you to take a contrary position. What was the argument by the National Assembly and the Senate before the Court of Appeal? The argument was the Deputy Chief Justice this function. And on the basis of that, kindly stay the proceedings before the High Court. I'm referring to number E097 of 2021. So the Senate and the National Assembly went and argued before the Court of Appeal. Don't allow those proceedings to go on before the High Court, because that bench, a 5-judge bench, is appointed by a person who does not have the authority to appoint. And the Court of Appeal considered that application. In the ruling, the court agreed with the National Assembly and the Senate. And the ruling does not have a paragraph numbers, but towards the end, now in finding that the Senate and the National Assembly had an arguable case, they said, as we have observed, of appeal on appeal is not one that will ultimately intended to be argued whether the Chief Justice was empowered by the said article, the article we are discussing, to empanel a bench of the High Court. It's not an legal point. It is an arguable point. It appears to us that if it was to be held on appeal, that the Deputy Chief Justice had no power to empanel the bench, the appeal would be a victory with no practical effect and academic exercise. So, the court also considered the third aspect, which was introduced by the Supreme Court in a previous decision, the public interest consideration. That this is a matter in the and it is proper that the appellant exhaust the appellant. So the court went ahead and said that the motion proceedings in the High Court and to date, the state. The appeal was supposed to be determined in the certain period of time. The appeal is still pending, and the proceedings. You are at the place it made a determination, it was taken. Have any decision where in these matters identify that the Deputy Chief Justice does not have power to empanel and obey.
Your Lordship and my lady, even may please you, my name for the third petition in this consolidated petition. Your Lordship, I want to begin to say that the proceedings that are before this court today are fruits of a prisoner's tree for the following reasons, my Lord. The first reason is that, Your Lordship, our matter was referred to the Honorable Lady Justice, the Chief Justice on 11th of October 2024 for empanelment of the same has never happened until the conservatory orders in petition E015 were granted. It therefore shows, Your Lordship, that petition E014 as consolidated with E013 are here to see the loopholes so that we cannot question why petition E015 was brought before this court before E014. Your Lordship, I just want to agree with all the submissions by my learned friend, and that is my submission.
Can I ask you address? Hearing of matters during night hours. We have to be respectful, my Lord, that judges can hear matters at all hours. I have done so. The colonial judges had cases at all hours in the middle of the night, early hours of the morning. I remember appearing before Judges, Chief Justice Simpson, cases with simple matters, like in the Rashford, the judge's home or the Chief Justice's home, I will be granted there. It's a beautiful custom, beautiful practice, and I invite you in this towards a good practice. Like in Mombasa, Your Honor, you would have foreigners who are girls, and they want now to fly out with this. The ships at odd hours, and you rush to a judge at night and he will give you an order. And have names of the judges in publications, like telephone directories, their telephone numbers. To grant your judges home because we know where he lives and so on, and he will grant you orders. We no longer have that type of thing at all. I recall one judge I appeared before, and he had me talking to his askaris at night, and he came out. Who is that? Somebody said, oh, it's a Kamima. He wants to come and jihad. And the judge, the word would be shocked to hear, or the country would be, you are only a judge during the day, and at night you are not a judge. My Lord, let us. But then, coming to in some case, what has happened is completely wrong. 148, 149 hours. If a person can become a president of the republic at any time. Now, if you are going to hear his matter regarding impeachment, you should hear it during the day and it should be heard in the practice. What the Deputy Chief Justice or whoever it is would have done is and asked them, can you come? But they should not have heard this matter. This is not a matter that you look at the Constitution, and the Constitution seems to be very clear. I will refer you to Article 165 of Article 165 of Article 4, which is the commitment that we do to the court. It says that Article 144, sub-article 4. Article 144, sub-article 4. But 144, sub-article 4. So first, yeah, if you look at that 144 of Article 4, yeah, if the Chief Justice is unable to appoint a tribunal under Clause 3, the Deputy Chief Justice shall appoint such a tribunal. So you see very clearly on where the Deputy Chief Justice can act. It is set out in the Constitution very clearly. Now in this particular case, it is not set out in the Constitution regarding impeachment. It does not confer power on the Deputy Chief Justice at all. If I may also refer the Lordship to impeachment relating to the Deputy Chief Justice, Article 144, Article 145, Article 150, Article 1B. Those provisions are expressed. Now, the next thing I may wish to deal with is if you could look at Article 165 of Article 4, 165 of Article 4. 165 of Article 4. It says that any matter certified by the court as raising a substantial question of law under Clause 3, B or D shall be heard by an even number of judges, being not less than 3, assigned to the Chief Justice. Now, before the Chief Justice appoints the 3 judges, he takes into account a number of things, my lord. He will take into account the experience of the judge that he is appointing. He will take into account things like whether it would probably be in a conflict of interest. He you take into account whether there would be objections from certain individuals and so on, when you not expect to do that at all. It takes into account a lot of things. It's not just an exercise where he writes down the names of judges immediately. He takes into account a lot of things before he appoints the one and so on. Now, in this particular case, Your Honor, this will not have, it's not power that can be delegated. The Deputy Chief Justice at all. It is specifically and expressly dedicated to the Chief Justice. Well, with the new technology we have, even if the Chief Justice happens to be out of the country, there's nothing that stops an individual or the registrar from getting in touch with him and explaining to her that if we have got this matter coming up, there is an issue of appointing 3 judges to here, can we have your views? And they would probably say that, why don't you have so-and-so, 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 and you actually assign the judges to get those matters. I would emphasize, and I also keep myself with my friends, that there have been miscarriage of justice. The Deputy Chief Justice should not have done what he did at home. Not that you have got anything against her. Not that you are alleging that there was something that she did which is not she should not have done. There is also the issue, Your Honor, when you are dealing with matters of this kind involved, the issue of perception. Perception is important. When a Chief Justice is performing, a Deputy Chief Justice is performing such a kind of job or exercising such a power, what perception are other people going to get? They may read a lot into what he has done. It will be correct or it will not be correct. But like this, when they come to conclusion, they look, the Deputy Chief Justice probably is acting under direction of the executive, under direction of the President. That may not have been done. But that is a possible perception. It sends the wrong perception to people. And when you are dealing with matters to do with administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the Deputy President of the country is being removed under suspicious circumstances. Is it wrong people to do suspect that the Deputy Chief Justice was probably referred instead of the Chief Justice? Is it wrong people to probably to the chain when they're having their task released that the Deputy Chief Justice is possible that the Deputy Chief Justice is taken because he's a friend of the Executive and such things and so on. So to make sure that we do not have such allegations, we stick to the law. So I emphasize before I sit down that what has happened is wrong, must be condemned, and we should uphold the submission of my elderly friends. That the Deputy Chief Justice made functions made or duties of the Chief Justice. Clearly, that refers to cases where the Chief Justice may be, or the Chief Justice may be sick, or the Chief Justice may be involved in something that is cannot yet perform the work and so on. Now, in this particular case, nobody has alleged the Chief Justice for something like that. Nobody was alleged to the Chief Justice of the King, and nobody was alleged anything that made it impossible for the Chief Justice to carry out activities at all. Again, I emphasize the question down on removal of the Deputy President as doctor. And it's something that is making a number of Kenyans entertain us of interesting things and so on. Yesterday, I think it was on Sunday, when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down. I decided to listen to the word of God from a lady preacher, and she was saying that, what's going on now? God no longer has any confidence in the current house. Now, you can't blame her. When such things were happening, you can't blame her to come to the conclusion that the Almighty God and Lord Jesus Christ no longer support the current government because of such things. I urge you that you have full submission of my understanding that the keeper and his chair colleagues, they are able to submission and to the name of God. Thank you.
May it please the court, we will try on the side of respondents to be precise and concise. Let me start off by thanking Dr. Ogada and Mr. Ongoya for their very kind remarks about the small role I have played in the development of our constitution and law. Thank you very much. I also want to thank Council for the civility that has been observed in the presentation of this matter, and I do hope that the respondents will also remain civil so that we extend the proper respect that the court deserves. I am instructed by the Honorable the Attorney General, a very eminent Dorcas Odwo, our first female Attorney General. And she instructs me to inform the court that she is here because Article 156, Sub-Article 6, enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest. The people of Kenya have a public interest in the maintenance of a stable government and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the institutions of government, be they the legislature, be it the judiciary, or be it the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government and that imperil the stability of the state. And that human rights are not only accorded to individual applicants, they are also accorded to the collectivity called Kenya. And the people of Kenya, they also have human rights. I agree with my learned friend, Mr. Ongoya, who is a very eminent constitutional jurist and a practitioner of the constitutional law. I agree with him when he says the Constitution 2010 in many ways is transformative has introduced more versatility in the protection of human rights. That is true. I also agree with him when he says that the Constitution must be construed in a manner to give full effect and protection to the rule of law and to human rights. But I further submit this, that the Constitution too must be interpreted so as not to create an absurdity. The Constitution must be construed so as not to create an absurdity or to put it in conflict with itself. What is the purpose of the Constitution? To establish the state. What is its further purpose? To provide for democratic government and to protect the rule of law and to protect human rights. These are not in contradistinction. These are not at war with each other. A stable government, a sovereign people, and human rights are not in conflict with each other. They are in harmony. It is the work of the court to interpret in order to create that harmony. When the court is invited to interpret the Constitution so as to create an absurdity, it must refuse to do so. This afternoon, you are being invited to interpret the Constitution to create an absurdity. Why is it an absurdity? The Deputy Chief Justice of the Republic of Kenya can swear in the President of the Republic of Kenya into office. What a huge power, what a huge authority. The Deputy Chief Justice of the Republic of Kenya can empanel a panel of judges, can appoint a tribunal to remove the president from office. What a huge responsibility. What huge authority. But wait a minute. The Deputy Chief Justice cannot assign duties to judges. Pray my lords. What then does the Deputy Chief Justice deputize? What does she deputize? In many jurisdictions, like those referred to by the distinguished counsel on the other side, in many jurisdictions, including the United States, there is no office of Deputy Chief Justice. In the Supreme Court of the United States, there is the Chief Justice and Associate Justices. In Kenya, the drafters of our Constitution, if I may say so myself with a bit of humility, I was one of the draftsmen. Knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll be very brief. That is to be found in the Constitution itself and in the statute. And I think I will leave my learned friend, Mr. Ngogo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 1 point, 2 points. Beneficiaries of ex parte orders stand before this court and say only they are entitled to ex parte orders. They are here to complain that they went before Judge Bongo, they went before Judge Mwita, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte, and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My Lord, I want you to remember, because it is in your file, the transmission from Kiriboya is in the portal. Unless my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, good evening, kindly find attached the document for your attention. It has a time to the Chief Justice. It is on the 18th, and it is 15:45. It is 3:45 in the afternoon. So when counsel repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend will continue.
Thank you. My lords, I will take it up from there. I will dive right into the constitutional questions. The application before you for challenging the empanelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Article 161, 2A and B, that establishes the office of the Chief Justice as head of the judiciary and of the Deputy Chief Justice as the Deputy Head of the judiciary, and conversely, my lords, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and is the Vice President of the Supreme Court. My lords and your lordship, it is now beyond our adventure, again quoting from the CTS, that while counsel submitted that there may be instances of delegation, they ignored, my lords and your lordship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the Laws of Kenya. The Judicial Service Act expressly provides, my lords, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. My lords, the CTS and my learned friend, Professor Gilligan, referred to this. There are only two professors senior counsels here, so it must be correct. My lord, in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that should be a way to Geneva, Switzerland, and Milan, Italy, between the 12th October 2024 and 24th October 2024. That is another issue. It's in the banner. It's on record. It's on record. Senior counsel and my pupil master Paul noted. It is the banner.
Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the portrait.
It is.
Or whether it is.
You taught me to submit politely. You taught me to submit clearly, and I'm polite. Yes, I was speaking. My lords and your lordships, it is therefore
important that in my address to the court, I indicated that the respondents in that application did not file any replying affidavit, through which this material could then be introduced before you.
My lord, it is part of the record. The record.
The material which is in the court portal is part of court record.
Your Lordship.
If it is not on the portal, it's okay. If the material is in court portal, it's part of the court record.
Mr. Ndegwa,
just for good order, my notes that we make progress. We know, because we access the portal to particular case numbers. In which case file is this material available, so we can just log in and be able to see it.
My lord, it is not in my place. You start educating or demonstrating my learned friends what file to look for. Because this is the portal. I would have had no other way of accessing.
Professor, can you just give us a reference?
Yes, I had.
For purposes of clarity.
Yes, my lord, 05, we have 3 cases that are consolidated. We have accessed the portal in E015 of 2024. Transmission Wanyama, and E014 has consolidated. We have this material, we are aware of it. We have even gone further, my lord, and served or passed on the communication to my land. It is the public domain, my lord. We could not have secured this communication anywhere else.
Sorry, Senior Counsel, do you mean to say that what you're holding is filed on CTS?
It is.
Does it have a date and time?
It is in the. What I have here is a copy from the CTS, with the reference of the Chief Justice Office. We only accessed it from the portal.
We are that's not straightforward. There's an internal memo we've just been given here. My colleagues are saying it's on the portal. If we knew the case number in which it was, we would have verified it. The other option would have been for my colleagues to be reacting a particular application this afternoon, have they filed an affidavit to this document. The truth of the matter is that the documents in the CTS have a timestamp, as my lady points out. The document we are having here does not have a similar timestamp. We're just saying show us where it is so that we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you're asked to authenticate. You do precisely that, you authenticate.
My lord, I can confirm that it is even in the physical file. This document, the physical file. So that my learned friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a process to verify. My lord, if I may, the issue is my time. They will have time to respond. Yes, the judicial report was. I can proceed.
My lady, I have a specific question. We want to know in which case file in the portal, because that submission my colleague has made, there's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we find authenticate. That's simple. My colleague Dan will say it is in the portal. He has a duty to furnish us with the particulars.
We have indicated, my lords, that it is in the physical file. My lord, Mr. Nyamod will specifically address them so that I can proceed.
Your Lordship, would you kindly give us a ruling on our objection?
Please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a rejoinder.
My lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, and the need for expeditious disposal of the application before you cannot be overstated. My lords and your lordships, time and again, my friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Of course, no doubt, my lord, this court has moved to the electronic age where matters are transmitted through
through mail and through other forms. But most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my learned friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application. My Lord, what we are dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my learned friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, all the orders obtained under the subject of this proceeding were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my Lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. The next phase, my Lord, would be dealing with the question of the next step. My Lords and Your Lordships, it is clear that my learned friends do not want to proceed with that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceedings, my Lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer in this. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the judicial. You opine, my Lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you.
My Lord, my ladies, as a follow-on to the submission by my two learned senior colleagues, I wish to respond further to the application as follows. There has been a lot of water under the bridge since we convened, or since this court convened at about 11:15 or 11:30 this morning. But as I am no doubt members of the court will be able to quickly figure out, the single issue that is before you is a challenge as to the regularity of this, of the referral of the 3 or 4 matters to this bench by the Honorable the Deputy Chief Justice, the Honorable the Deputy Chief Justice of the Republic of Kenya. And I wish to commence my response to that objection by saying as follows. The Chief Justice occupies 3 distinct constitutional offices. 3 separate and distinct constitutional offices. First, the Chief Justice, by dint of Article 161, sub-article 2A of the Constitution of this Republic, is the head of the judiciary. By dint of Article 163(1, the Chief Justice is the President of the Supreme Court. And by dint of Article 248, sub-article 2E, the Chief Justice is the chairperson of a constitutional commission established under Chapter 15 called the Judicial Service Commission. Members of the court, I wish to take just a moment to demonstrate how the Chief Justice is deputized in these three distinct constitutional offices. In respect of her capacity as the President of the Supreme Court, Article 163, Subarticle 1B is clear that the Chief Justice shall be the President of the Supreme Court, A, and that B, the Deputy Chief Justice shall deputize for the Chief Justice and shall be the Vice President of the Court. That is the first constitutional office. The second constitutional office is the head of the judiciary, and I will come back to Article 161 in a moment. Suffice it to say that it is in Article 161, Subarticle 2, that the office of the Chief Justice is established. And Article 161, Subarticle 2 states as follows: there is established the office of the Chief Justice, who shall be the head of the judiciary. I will come back substantively to 2B in a moment. But it is important that for the purposes of the commission established under Article 248, Subarticle 2E, the Deputy Chief Justice is then not the Vice Chairperson of that commission. In the Judicial Service Commission, the DCJ does not deputize the Chief Justice. Now, it is our position for the respondents that the function that the Chief Justice exercises under Article 165, Subarticle 4 is the function set out in Article 161, Subarticle 2A. That is not the President of the Supreme Court, that is not the chairperson of the Judicial Service Commission, but that function is exercised by the Chief Justice in her capacity as the head of the judiciary. It is our submission that therefore the Deputy Chief Justice, who is the Deputy Head of the Judiciary, by dint of Article 161, Subarticle 2B, can exercise the function of the Chief Justice as Deputy Head of the Judiciary. And members of the court, Article 161, Subarticle 2 creates three positions: the Chief Justice, the Deputy Chief Justice, and at Subarticle C, it creates the office of the Chief Registrar of the Judiciary. Now, the Chief Registrar of the Judiciary doesn't deputize the Deputy Chief Justice, but the Deputy Chief Justice deputizes the Chief Justice. That does not require any interpretation. That is really comprehension as a matter of English. It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act as the head of the judiciary, the Deputy Chief Justice can then perform that function. Members of the court, I submit that the decision in Lina Concella is good law. And the facts in Lina Concella are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Concella was the Chief Justice. The only respondent in Lina Concella was the Chief Justice. If, for the sake of argument, we go along with the submissions made by our learned colleagues for the applicants this evening, that the Deputy Chief Justice then cannot deputize for the Chief Justice, then in Lina Concella, when a judge of the High Court certified that the issue in that matter was one fit and proper for an expanded bench under Article 163.4, 165.4, then going by the argument, then there would be nobody to empanel the bench, because the Chief Justice was a party. How can he or she empanel a bench in a party where there are respondents? That is the absurdity in the argument by the other side. And my lord, it is our submission, or it is our position, that the constitution of this republic must remain elegant, and it must remain functional. Interpretations such as the one urged by my learned colleagues for the applicants that would lead to that sort of understanding should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution only means what the courts of law in the Republic of Kenya interpret it to mean. And it is the interpretation of the Constitution that gives it life, that gives it meaning. And, my lord, my lady, it is therefore my submission that it is a proper interpretation of the Constitution, flowing from the express provisions of Article 161, sub-article 2A and B, that your empanelment was regular. As I take my seat, I wish to submit that I am in no doubt that as you sit as the three judges presiding over this matter this evening, you have no doubt as to the regularity of your empanelment. Because if you did, and flowing from the accolades that have been heaped upon you by learned counsel for the applicants, then you would not touch this file. There are other files that are equally urgent, that deal with the same issue, that have been brought to your attention this morning, this afternoon, and maybe again this evening, where you have said, in the absence of that direction, under Article 165, sub-article 4, you are unable to deal with those matters. So, my lord, my ladies, being satisfied, or you being satisfied with the regularity of your empanelment, this application is for dismissal. And I must add, with costs. So that the important substance in this matter can be determined by the court. I'm most of that.
My lord, my lady, permit me to just conclude with giving a bit of a context in the Coachella matter. I'll not go into explaining anything because, my lord and my lady, the decision speaks for itself. The decision is a decision of 5 judges of the High Court. In particular, my lord and my lady, paragraph 97 is instructive. 97B in particular, if I may, reads that the exercise of powers under Article 165(4) of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature, the said mandate can be exercised by the Deputy Chief Justice when the Chief Justice is absent, when necessary, or if for good reason the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my ladies, that is the absurdity that learned senior counsel, Professor Gizo Ugai, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case that no matter that requires constitution of a bench will be heard or determined? That certainly would be an absurdity that the law would not have contemplated. That said, my lords and my lady, one of the things that will play out by close of business these submissions is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for two primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Muja Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter partes hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024, before the court in Nairobi, and E015 of 2024 in Kerugoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my lady, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours, including a possibility of being heard on a Saturday. My lords and my ladies, that prayer was not granted by the court. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mongo and the Honorable Justice Waita in the Nairobi matter. Again, my lords and my ladies, that prayer was not granted. What followed was then the court, as would be the normal practice of that court, gave directions on how this application was to be dealt with. That is how we ended with the date of 22nd of October 2024. And why this is important, why is it their case that when they file an application and get orders, it is convenient, it is okay, there is justice. When they get another order in Nairobi, it is okay, there is justice. When we get an order merely certifying our matter as being urgent, then there is, all hell breaks loose. And we are saying, if only our colleagues had sought to present this material before this court, we would not be talking about what we're talking about now. It would have been manifestly clear that we were here on account of an application. My lords and my lady, I've had very strange submissions coming up this afternoon. Submissions including that at the ex parte stage where the court is supposed to be giving directions, the parties expected that the court to have been given notice. Since when, my lords, do the courts in this division, and indeed any other division, attend to matters under certificate, and at the ex parte consideration of those orders, invite parties for hearing of those orders? Why then do we call them ex parte? That submission, my lords and my lady, I repeat, is not for the consumption of this court. That submission can only go to serve an audience that is outside this court. Because the people in this court are fully aware of the rules governing the conduct of matters of this court. My Lord, allow me a few more minutes just to point out a few other areas which then would speak to the reality of why then the omission of this material fact is then now being used to place this insinuation that the court either did something that was untoward or the Honorable, the Deputy Chief Justice did something that is untoward. My Lord and my Lady, at paragraph D, the respondents in the application say, subsequent to the reference of a matter to the Chief Justice on the 18th, the petitioners reasonably expected that once the Chief Justice issued directions on the file regarding empanelment, the petitioners would also be invited for mention before the bench for directions as was directed by the Honorable Judge. If they didn't have an application, on what basis, therefore, was an order going to be issued to them? One would have expected that that would be something that would come from a party not represented. The represented would certainly be talking to an audience other than this audience. They say they now have a direct accusation on her leadership, the Honorable Deputy Chief Justice, said that the Deputy Chief Justice violated Article 1, 10, 27, and 50 of the Constitution in ordering this bench to hear and determine 3 matters in which conservatory orders. Then there is no such order that came from a perusal of the file would speak for itself. All that the Honorable, the Deputy Chief Justice did was to constitute the bench. And if anything, this same bench is a bench that had been constituted by the Chief Justice herself. Questions that we ask ourselves. Why is it that when we appeared before this very bench last week on Tuesday, on the hearing of their own application, we sat up to midnight? Today, because it is the issue is on the other side, it becomes popular. That cannot possibly be a parity of arms when you're dealing with a question of justice. Why is it that when they went all over asking for orders, and this speaks to why there are only 2 matters that came before this court, they filed a number of cases. In those other cases, there were no orders. What business did we have filing applications in those matters? We only felt that we were aggrieved with these orders specifically because the effect of those orders were to suspend a provision of the Constitution. And that's why it's important for us that we deal with them. As we seek to deal with them, the only way that the rules of this court establish is that we make an application. My Lord and my Lady, I look at, finally, I think, the drawer number L, that they also sought to know the circumstances that led the Chief Justice to delegate to the Deputy Chief Justice. That I think has been spoken to. My Lords, my Ladies, what then comes out is that if our counterparts had been candid with the facts in the file as they speak, we would not be wasting time as we are right now. We would have had an opportunity to speak to the matters on the basis of the accuracy of the files. We would not be casting aspersions on the court as we have seen. We would not be casting aspersions on her leadership, the Deputy Chief Justice, as we have seen. We will not be casting aspersions on the Chief Justice as we have seen. My Lords and my Lady, I repeat that that submission is meant to achieve 2 reasons, and 2 reasons only. 1, to delay the proceedings that are before you today. We have an application, and at the right time we'll be seeking and insisting to have it had. And number 2, to then create this negative impression, which I suppose is meant to be used at a later stage. I rest my case.
Thank you, my lords and my lady. My name is Morugaba. I wish to submit only on 2 points of law which were actually articulated in support of the application. And these were that the proceedings before this court touch on the Bill of Rights, and they are vitally important that we should actually not be seen to flout the Bill of Rights. The Bill of Rights is Chapter 4 of our Constitution, runs all the way from Article 19 to 50. But I wish to remind the court that the Bill of Rights applies to every party that comes before the court. and it's not just one party. The proceedings we have before the court are very important to the petitioner. They are equally important to the respondents. And it goes without saying that over 50 million Kenyans actually have an interest in these proceedings, and this is the reason why the agency has been certified both ways. My judges, aspersions have been cast on the bench so as to call for this recusal and application of Article 165(4), that you're being drawn into a conspiracy to commit injustice because there is no emergency that requires you to hear this matter as a matter of emergency. Far from the truth, the two applications that are before you to set aside the conservatory order are as important as the applications that led to the granting of those orders. Therefore, the hearing of those applications must be speeded up, and we are able to move with the matter ahead. You've also been accused of being enlisted in the service of the violation of the Constitution. Again, far from the truth, because this is an allegation being made against you, while the position of the respondents is that justice must be served expeditiously and as required by our Constitution. Finally, Article 165(4), which uses the word assign and not appoint. Inasmuch as this is a constitutional responsibility for the Chief Justice to assign, it is purely administrative. The word used is not appoint. We are using other words like empaneling and what have you. But, sorry, the word used is assign. And therefore, if the Chief Justice is not able to assign, nothing stops the Deputy Chief Justice from making the assignment. That is number one. Number two, where it is expressly provided in this Constitution that in the absence of the Chief Justice, the Deputy Chief Justice would act, relates to Chapter 9, where the Chief Justice is dealing with the executive. In this particular instance, we are dealing with a judiciary where the head of the judiciary is the Chief Justice, deputized by the Deputy Chief Justice. So I also urge you to find that in fact there was nothing wrong with the Deputy Chief Justice in the absence of the Chief Justice assigning the judges who were to deal with these two applications that were before them that particular day and the next applications which had been filed previously. Thank you.
My Lord, in 2 minutes, my Lord, as you retire to consider the application, Midimo is my name, my Lord. I would invite you to consider Article 259, my Lord, Sub-Article 3, and particularly, my Lord, B and C thereof. And if you allow me, my Lord, I will read it out. And it states that every provision of this Constitution shall be construed according to the doctrine of interpretation, that the law is always speaking, and therefore, among other things, B, any reference in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing, my Lord, underline, otherwise performing the functions of the office at any particular time. My Lord, it's not disputed that the CJ was out of the country, and that, my Lord, the DCJ was performing the functions, my Lord, of the CJ at that particular point in time. And, my Lord, our attention has been drawn to the communication from the CJ that he particularly asked the DCJ to take charge. My Lord, therefore, Article 259 3B provides an answer to the question that is before you. And, my Lord, lastly, I'll read Article 259 3C, which reads, my Lord, and says, a reference in this constitution to an office, state organ, or locality named in this constitution shall be read with any formal alteration necessary to make it applicable in the circumstances. My Lord, the circumstances before you were that the CJ was not available to give the directions or assign the bench. What the DCJ did, my Lord, was applicable in the circumstances. I invite you, my Lord, to refer to that petition when you be making your ruling. I thank you.
My Lord, I represent the Speaker of the Senate. My Lord, allow me to make very brief submissions without repeating what my colleagues are saying. My Lord, allow me to start by quoting Article 145, paragraph 7 of the Constitution, to just contextualize the reasons for our application on Friday last week. My Lord, if you look at the provisions of Article 145, paragraph 7, my Lord, the impeachment of a deputy president is a serious national stability matter. My Lord, because after a vote by the Senate, in accordance with Article 145(7), the deputy president, my Lord, it says at least 2/3 of all members of the Senate, when they vote to uphold any of the impeachment charges, the president shall cease to hold office. In this case, as contextualized, the deputy president, the former deputy president, in this case, Mr. Gachagua, ceased to hold office. My Lord, look at it also in the context of Article 22. My Lord, this former deputy president, in exercise of his right in the Bill of Rights, my Lord, moved the courts by way of a petition. My Lord, on Friday, that 18th of October, 2024. My Lord, conservatory orders were issued, which, in accordance with the petition, with the respondent's perspective, appear completely problematic. And my Lord, they required immediate intervention in terms of the respondent, my Lord, moving the court. Because, my Lord, the flip side of Article 22 is that whereas you have a right to file a case in court and seek conservatory orders in accordance with Article 23, paragraph 3A, a conservatory order which is discretionary. It means you are suing a respondent. Well, that respondent equally has a concomitant right to move to court, to interfere, to set aside, to ask the court to vary that conservatory order. My Lord, the grant of that conservatory order is discretionary. So, my Lord, there is nothing cast in stone in terms of the respondent, my Lord, coming to court to make an urgent application for the setting aside of that conservatory order. My Lord, there is also nothing strange for the court in public interest. My Lord, for the court in public interest, having looked at the grounds of this application to set aside these conservatory orders, my Lord, for the court to apply Rule 3 of the Mutunga Rules, my Lord, to make a just, expedient, and my Lord, proportionate decision in terms of directions on how to dispose of this matter. My Lord, again, under Section 60 of the Evidence Act, we all need to take judicial notice of the fact that my Lord, now we have the e-filing system. My Lord, when such extraordinary matters come to court, my Lord, the court is empowered. My Lord, at any time, my Lord, at any time of the day, my Lord, at any time, to access the system, and my Lord, to give appropriate directions for the expeditious resolution of this dispute. My Lord, they benefited from these orders. on Friday. My Lord, unlike them, my Lord, we had the courtesy, because my Lord, we saw the court orders in the social media, and we responded accordingly. But my Lord, unlike them, we were courteous enough to serve the orders which were issued by this court to the respondents. So it cannot lie in the respondent's mouth to say that they have been ambushed to come to court, to the extent that they come to court and say that we are acting under protest. We did serve them with these court orders. And my Lord, on the last aspect of that point, is that, my Lord, then this petitioner who has come to court under certificate of urgency, my Lord, having absented himself on, at the Senate on Thursday for health reasons.
May I praise you?
I think that is
My Lord, I'm just winding up to emphasize.
But he did not absent himself. Sickness is not absent himself.
My Lord, I can rephrase. My Lord, I can rephrase. My Lord,
but
this
petition
petition
as well avoid it.
Yes, my Lord. This petitioner.
May I say he apologizes?
Let him avoid it.
Yes.
Let him avoid it.
I'm avoiding actually that.
He has avoided it.
Avoided. Justice administered without mercy and wisdom is not justice. Here you got someone who is in his 60s, he's saying he's sick, he has cardiological problems, and you come and say it down. These are principal advisors of the government. They must be whatever.
My Lord, can I now conclude?
Can you do that?
Yes, my Lord, I was making a contradiction by saying that the petitioner was able to access the court expeditiously, and the court was able to grant him conservatory orders on Friday. My Lord, the same petitioner cannot then come to court and complain. My Lord, complain when, my Lord, the Chief Justice, my Lord, the Deputy Chief Justice, my Lord, in public interest, and given the extraordinary nature of this matter, my Lord, gives directions that this bench be constituted for purpose of determining the underlying question. My Lord, the petitioner cannot probate and reprobate, can't speak on both sides of the mouth. So, my Lord, the other extraordinary nature of this matter, my Lord, is that the petitioners have filed a multiplicity of suits. My Lord, you have heard that there were 3 cases in Ikeregoya alone. My Lord, other cases were filed in Nairobi. My Lord, Kenyans, my Lord, this is the consumption of justice. My Lord, just a few days ago, the Chief Justice had appointed this bench to determine these matters for the satisfaction of Kenyans. My Lord, in the public domain, Kenyans are aware that this bench has been appointed. So, my Lord, what is wrong? What is so different? What is so strange for the Deputy Chief Justice when the Chief Justice is away? Again, for the same reason, for purpose of expediency and my Lord, for purposes of laying a multiple basis for consistency in judicial decision making, for these matters to be brought before this bench by way of a direction in terms of uses being used in this matter. So, my Lord, I don't see anything extraordinary. My Lord, as I wind up, the petitioners have just simply cast aspersions to the process of appointment. There's nothing cogent. Lord, I don't see any integrity issues with respect to the handling of this matter by the Chief Justice. I don't see any integrity issues with respect to the handling of this matter by the bench. So, my Lord, our plea, my Lord, our sincere plea is that the underlying dispute with respect to the setting aside of the conservatory orders, my Lord, in accordance with the directions which were issued, should be urgently determined, my Lord. My Lord, in public interest. Thank you.
My Lord,
My Lord, for the fifth respondent, I'll be very brief. I just wish to
remind us.
Yes, Dr. Kamoto, I think the fifth respondent. For the sixth respondent now, it's a new order. First, I wish to set the record straight in terms of some misrepresentation that has been made with regard to the decision cited, the Reina Conchera decision. When the petitioners were submitting, they were not aware that I am one of the petitioners in this matter, and that I am fully versed with the entire set of facts. So they misrepresented that the matter is not active. Nothing can be further from the truth. This matter is active. It was mentioned on the 24th of September 2024 before a new bench that was constituted following the accession of the honorable judges who are previously dealing with it, and it is due for further mention on 30th of October 2024. So the decision remains solid in terms of its capacity to persuade you not to depart from it, because no reason has been supplied, save for the misrepresentation that it should not be utilized. Now, allow me, my Lord, to make reference to the High Court Organization and Administration Act in light of the issue that has been raised on the sittings of the court. I will briefly cite verbatim Section 10 on the sittings and recess sessions of the court, where it is quoted as follows: that the court shall subject to subsection 2, 3, and 9 sit continuously for the trial of criminal cases and disposal of civil and other legal business of the court. There is no disclaimer whatsoever with regard to the time that the court should sit. So the court can sit at any point in time, day or night. Indeed, today, when dusk came, I was apprehensive that counsel for the petitioners might leave, since the court is sitting past working hours, presumably. So the point that must land home is that nothing prevents this honorable court from sitting at any time, such that then the issue of when the court sat, when the files were transmitted, when the orders were released, whether on Saturday, whether on Sunday, though it has not been shown that is what transpired, the court has liberty to sit on such occasions if need be. With regard to the issue of the empanelment by the Deputy Chief Justice, again on this account, the petitioners have misapprehended the import of Article 165(4), because what is fundamental is that there be a substantial question of law, and that question of law is certified on the discretion of a High Court judge. What that means is that the same issues that are being heard here today could have been heard by even a single judge, if at the discretion of the judge who handled the matter reasoned that there was no substantial question of law. So what the Honorable Chief Justice or anybody else capable of exercising the powers within the office of the Chief Justice does is administrative. all the High Court judges are qualified to deal with matters of such nature. All of them. So assigning one or the other is routine. It is purely administrative. There is nothing that is exceptional intellectually in terms of requiring a special exercise of powers when it comes to dealing with that aspect. So in a nutshell, I would wish that, to point out that in a hurry to come to court, the petitioners even wrongly enjoined the sixth respondent, His Excellency the President, when Article 143(2) is clear that no civil proceedings can be instituted against the President. A decision that has been affirmed by the Supreme Court in the decision of Attorney General and 2 others versus D and 79 others. So the Supreme Court made an express order that the President cannot be sued. It's an order. So the pleadings that have been lodged before this court have been filed in context of the Supreme Court decision, and they should amount to nothing in the full final set of facts. So I'll be seeking that the bench continues to stay put, so that as early as possible, I can seek to have the sixth respondent discharged from the irregular proceedings initiated by the petitioners, and which they don't want concluded. They want to thrust this country into a crisis. Under Article 146, there is possibility of the office of the President becoming vacant on account of various issues, either through death, which is uncertain, through resignation, because he can take a resignation and decide that I think I've had it too much, he can take a resignation, or any other reason that may arise. So at the moment, upon the Senate voting on the first ground of impeachment, we stood without a deputy president. So what would happen in the event we have a vacancy in the office of the president? We are staring at a crisis. We don't have a deputy president. The Honorable Speaker of the Assembly can only serve for 60 days. We don't have an IBC. So what the petitioners are doing is fomenting a crisis of monumental proportions, which we will not be able to fight about. So I humbly pray my Lord, my Lady, that you fight favor in the arguments of the respondents and dismiss the application by the petitioners. I
presume not email over.
My friends are referring to the judge at the right of Justice Mrima.
Because I grew up in a I don't have the problem of a nail. So
Are you the only person submitting now on this side?
Yes, I believe in my minutes, the 20 minutes, I want to do 15. There were 20 minutes, yes. And I said I'm doing 15. Is now lawyer will do 5. That's what I'm saying. So he asked for 20, I'll do 15.
All right.
And the Camino, because of seniority, is asking for 5.
So you use how many?
No, my Lord, I have to use 15. There were very many people who say no. So I need 15 and give Mr. Ongoya. My Lord, let me start at least for one point. My Lord, my learned colleague, Mr. Degwa, whom I respect a lot, is saying that probably we start with 2 points raised by our learned colleague, Mr. Joseph Kamodo. My Lord, the first thing, what is it? Okay. My Lord, the first thing is that the president cannot be sued. My Lord, for purposes of my understanding of the Constitution, everyone under the Constitution of Kenya is subject to the law. That is what the Constitution says. There is nothing the Supreme Court or any other court can say as valid law to change that position of the Constitution. So to the extent that the Supreme Court, assuming it ever said such a thing, that cannot be good law in the face of the Constitution saying everybody is under the law. Second point, my Lord, what is the nature of the proceedings? These are not civil proceedings. These are constitutional proceedings. If Article 149 of the Constitution says the president shall do this, there is nothing in Article 156 that would entitle the Attorney General to be sued on behalf of the president. Because the Constitution itself says the president shall do this. My Lord, also, if this is Bill of Rights enforcement, if the petitioners are saying the violator of the law is the president of Kenya, then the mandate of this court is to ensure the president does not violate the Bill of Rights. Nobody else can be sued on his behalf. I think we have done with that preliminary issue. Oh, and there is these issues of vacancy. My Lord, I was imagining that if this vacancy is troubling anybody in Kenya, 2 things. Number one, you would have seen some urgency in reconstituting IEBC. Some of the petitions that are before you, or that will find your way to your hands, are also saying the president cannot do what is so desperate to do because there is no IEBC. So that is coming. So if there was any urgency, anybody who cares about vacancy, let us start with IEBC. My Lord, also, if, and I think Kenya are entitled to this information, Mr. Kamodo appears sorry that a vacancy in the office of the president may arise. Perhaps this is information the people of Kenya are entitled. Why is that so?
My Lord, it's pure conjecture.
Well, I'm not saying anything. I've heard it there.
Unless you have some...
I don't know. I did say it. I did say it. Yes, my Lord, now coming to the main issue. My Lord, this forum, somebody said we are sitting past the desk. It made me remember something. I think I saw the presiding judge was practicing at some time when I was practicing as a lawyer in the 1990s. And I remember going to court very many times with Dr. Kaminwa, Paul Muite, and Gibson Kanal Korea. What was it all about? My Lord, during that time, and when we go to those cases, there was no distinction that was made.
My Lord, with your very kind permission, I'm constrained to just want to get some clarification. Are we re-urging the application?
No, I'm
because
responding.
The role you have in Illinois, you are supposed to be responding to issues that have arisen. I don't think what you're speaking to has arisen, and there is no latitude that extends to that direction. My Lord, we stand. We want to get some guidance.
My Lord, I believe those issues...
Mr. Kidd, you had the clarifications earlier,
yes.
But now just stick to the reply according to the...
I'll do that. My Lord, one of the cases that during that time, because you know you can't address every little issue. I'm trying to be global. My Lord, one of the, and these are global points I'm making in regard to the issues that have been raised. My Lord, you are effectively being told the petitioner and the respondents occupy the same space from the standpoint of our constitution. My Lord, the truth is they don't. And I say that for the simple reason that these constitutions of Kenya was made explicitly to protect citizens who can suffer from harm from the executive and people who occupy power. That is what the protections are meant to do. Conservatory orders are given to ensure people whose rights are being violated are in need of protection. That protection will be recorded. So somebody to say that an application for conservatory orders stays on the same level with an application by a violator to continue or to complete the violations, my Lord, that would amount to misreading the Constitution. And this is not an idle issue. Under Article 20, it is very clear. The Constitution binds all state officers and this court. So the notion that we have a right to be heard, yes, when we shall be doing the petition, give them 10 hours and we shall not object. But let the subject matter be preserved. We've got no problem. The right to be heard under Mutunga rules is protected. But there is a distinction under our constitution between a violator and the victim of violations. That one is very clear in our jurisprudence. Now, having said that, there is another office. There is a question of the empanelment, whether you call it assignment, appointment, the issue is, for purposes of Article 165 of the Constitution, does the Chief Justice exercise judicial or administrative powers? I go with what Dr. Kaminwa says. These are judicial powers. And judicial powers, my Lord, takes us to the oath that is prescribed by believing in that schedule of the Constitution. When the Chief Justice says, takes an oath, it to exercise the judicial powers that includes, with regards to the High Court, the powers under Article 165(4) of the Constitution. No such oath is taken by the Deputy Chief Justice to enable her to do so. So that, my Lord, as long as, if you say it is administrative, we go to another level. The questions would be, can this be made without a formal judgment where the issue has arisen directly? Because as you were told by my learned colleague, Mr. Waduka, that matter is still yet to be decided by the Court of Appeal. My Lord, having said that, there is a question my learned Professor Muigai, whom I learned a lot from him. My Lord, Professor Muigai talks about public interest, the issue of the necessity for it, and about a vacuum arising. My Lord, the happy thing about the Constitution is that up to this time, the petitioners have done nothing that would elongate the time at least of 74 to 100 days that is envisaged under Article 149 of the Constitution for this business to be conducted. If anything, it is this kind of applications to set aside that will prevent these petitions from being heard, for example, in the next 30 days, so that there is still some other 30 days for the people of Kenya to be consulted on this issue and the regular decisions to be made by Parliament. My Lord, there is an issue that an absurdity is being created. Who is creating an absurdity? The absurdity, my Lord, that is being created is this. And strictly speaking from Article 25 of the Constitution. Article 25 of the Constitution says the right to be heard is absolute, even during an emergency. How can this right ever be absolute, and this court were to take away the subject matter before that right is exercised, and you do not call that an absurdity? We are actually here to prevent that absurdity. In fact, you can have a ranking of absurdity. The biggest absurdity, my Lord, would be this, Article 125. All rights under Article 24 can be limited. Under Article 25, the right to be heard is absolute. It is binding on everybody. That's the biggest absurdity that can occur. Who supports that absurdity? The respondents. My Lord, we go next to Professor Ojienda. Of course, Professor Gedu said many things which you cannot deal with all of them. This internal memo, why is it? Oh, it's here. It's here. My Lord, this internal memo, first of all, we note, when the question was asked, is it anywhere? It is not in the CTS. Certainly. Number two, or portal for the cases that have actually been filed. My Lord, the second issue, there is no reply affidavit for this court to be able to deal with it. But what does it actually say? It says, during my absence, I request you, your lordships, to be in charge. I will, however, be available on email or telephone for consultation. My Lord, the last sentence, plain meaning of English, would mean to me that Chief Justice from Geneva or anywhere else she was cannot be able to carry out certain administrative functions. But when she says that to be consulted, this was clearly made in the knowledge that there are certain things that I must do, notify me, so that I can do them. The appointment of judges could be made by the Chief Justice in accordance with the constitutions from Geneva. My Lord, I could have said more, there is not much time. My Lord, they say they are challenging ex parte orders. My Lord, what ex parte orders is the main issue. The ex parte orders we are challenging is a conservatory order to ensure that before this court, there will be integrity and the constitutions will be upheld. And the kind of circus we had in Parliament will not happen before me. My Lord, my Lord, for purposes of where do we want this matter to be completed? My Lord, they said this is that they want the matter to be completed. We are more desperate for this matter to be completed. And that is why in the expectation of the petitioners, we expected that the first business of this court, like it happens every time I sit on benches, and I've sat on very many, they say, this matter is very urgent, we cannot hear preliminary matters, let's go straight to the petition. So we are very desperate to have this matter happen. My Lord, there is my learned colleague, Mr. Nyamodi, whom again is a good friend of mine, I respect. CJ occupies 3 constitutional offices, I agree. But the only issue of distinction is, under Article 165(4) of the Constitution, she cannot be able to perform that function any more than we could say she could transfer judges. Transfer of judges is actually more or less administrative, but she doesn't do it because it is an important office that goes with the office of the Chief Justice. But if this is judicial, she cannot be able to do it. My Lord, the issue of Conchela, again, the issue is contextual. The Chief Justice was a party, and therefore in Conchela, as far as I am concerned, the matter, the Deputy Chief Justice did so as an acting Chief Justice. Even Gachagua or anybody else who gets into that position, when they are acting as acting president, there are certain decisions that they can make, but they must wear that position. In this letter, there is nothing that suggests that the Deputy Chief Justice was turned into an acting Chief Justice by the CJ. Equally importantly, there is no express delegation that my powers under Article 165(4) would now be performed by the Deputy Chief Justice. My Lord, the issue of Segumbo came with some funny issue on of material facts. I do not know, I struggled to listen that we have concealed anything. Now, as anything, we actually even did an affidavit. They had the right to do an affidavit. It is not indicated that this document, which was in our possession, as I understand the law of disclosure, we failed to disclose it. All the other issues they are raising are points that are in contention. That does not amount to concealment, as I understand it within the law. My Lord, there was the question that no basis for Getonga Murugaro. Getonga Murugaro, sometime to rush. Murugara. Okay.
That's very sorry.
Oh, that's okay, my friend. My Lord, he says, and I agree with him, that this matter is very important for the 50 million Kenyans. I could not agree more. A matter that is so important to 50 million Kenyans, the least that could be expected is that proceedings are going to be conducted in open, without suspicions, without undue hurry and pressure. But my lord, if the petitioners, and already they are feeling, I'm feeling pressured and I started to do, if the petitioners feel that they are under pressure in a certain matter, that is not an express emergency under the constitutions of Kenya, it leaves a big question mark. If for some reason there is a desperation to turn businesses that the constitution say you should do it within around 80 to 100 days into 4 hours, there's a big problem, and that must be addressed. I'm about to finish. My Lord, so that for purposes of those issues, I agree with him. It just points out to the care that must be taken that these proceedings are not misunderstood. This court in particular must not be understood that it was under undue influence, that we must wear somebody Wednesday, Thursday, or something like that. This must be done within the four corners of the Constitution. If that one is not done, my Lord, there would be a huge problem, not just of perception, but the huge problem that in Githongori versus Republic they were talking about. The world, Africa, and everybody else is watching. And what are they watching? How are we going to consider to reduce time, for example, that is expressly set out in the Constitution in 2 hours? And to do what? To prevent a victim of constitutional violations from urging petitions that are before the court. That should worry the court more. 2 points that are remaining. Mr. Wanyama, I have to choose between Wanyama. Oh, Wanyama is the last one. Now, the issue of Wanyama is national stability. We made several points. That is probably the only one I will address myself. Mr. Wanyama can do the rest. This issue of national stability is actually very important. I agree with him. The issue of the impeachment of the deputy president raises the issue of national stability. For the simple reason, and this is why we must hear the petition, the deputy president, my lords, and as we understand elections in this country and the Political Parties Act, was not just a holder, the way you can appoint Kibe Mongai to be a legal officer somewhere. He was not just a holder of the office of deputy president. There was a political process in order to be able to get power under the Constitution in the 2022 election. That's why the issue of national stability arises. His supporters and also the president, they came together to form a party. So that, my lord, over and above, and there is a case which I was privileged to do in 2013, one of the lawyers in that case, this one of conflict management, when Ruto and Uhuru were being prevented from running for presidency in 2013. That case, my lord, and we did it before 5 judges, it was civilized, it was decent, there was no hurry. But more importantly, what was the issue there? Part of the issues that I was present in that case to urge is that President Uhuru and the now President Ruto are not seeking this case by themselves. Because Article 38 of the Constitution says they are doing this. The peoples in exercise, their supporters, in exercise of their political rights under Article 38, prefer these people to be their candidates. So what's my point? My point is this. Look beyond regarding Gachagua. Look also to the people who feel we've not been given a square deal and we are being disenfranchised, we are being emasculated from the political scene. We shall urge that more during the hearing of the petitions. For now, let us hold the ring. Let us not take away the ring so that we can meet sometime next week and deal with the issue. My learned colleague, Mr. Ongoya, can take it from here.
You're arguing right now.
No, my lord, I have finished. My learned colleague is somewhere to say something.
My lord, my lady, I just have a few points to highlight. There's a question by Dr. Kamoto on misjoinder of his clients. Let me just make a simple point that to the limited question whether the DCJ can constitute this bench under Article 165 Clause 4 of the Constitution, the question of joinder, misjoinder, non-joinder is absolutely irrelevant. It does not bear that question completely, and that will be a straightforward answer to that issue. Mr. Kamoto also said that this court can sit on any day, at any time, continuously. Section 10, subsection 7 of the High Court Organization and Administration Act 2015 does not support his argument. That section provides, and I quote, the Chief Justice may, where necessary for the expedient and proper exercise of judicial authority, authorize the sitting of the court on any day or at any time. The sitting of this court on any day at any time requires express authority of the Chief Justice under Section 10, subsection 7 of the High Court Organization and Administration Act. My learned colleague, Mr. Nyamodi, made an important point, and I think I support that point. The Constitution says what it says, but it means what the court says. Very crucial point. The Constitution at Article 165, Clause 4, says who can constitute this bench. That is the Chief Justice. Can the DCJ also do it? Is that an administrative or a constitutional mandate? The jurisprudence by this court, as we have alluded to, is 3 cases. The Umtata case, the Kemri case, and the Leila Conchela case. The Umtata case and the Kemri case present that as a constitutional mandate of the Chief Justice. The Leila Conchela case at the High Court level presents it as an administrative function, but we now know that the Court of Appeal has found that to be an arguable point on appeal and has given a stay order on the strength of that arguability. The weight of that jurisprudence militates against finding that this is an administrative decision, as has been urged by my colleagues from the other side. Since I've only 5 minutes, an issue arose here, my lord, my lady. We tried to object, but we were told we will have a right of reply. Professor Agenda presented a piece of paper from his hand, claiming it's a memo from the Chief Justice. We sought clarification on where that paper has come from. First, his argument was it's in the portal. We sought to know in which case file in the portal that paper has come from and why it has no time stamp that is symptomatic of all documents that are lodged in the portal, and there was no clarity on that. He then said Mr. Nyamodi will comment on it. Mr. Nyamodi stood, began, and concluded his submissions without commenting on it. He also told us it is in the file. Papers like this will find themselves in the file through affidavits. This is evidentiary material. Again, we were not told which affidavit or which deponent filed on which day. We will therefore urge you that as you consider this matter, you take into account that we have not had a fair opportunity to treat this piece of evidence in its proper context because of the, with respect, woolly nature of the manner in which it has been presented before this court. I urge, my lords, that in view of the matters raised before you, this matter ought to finally clear the position of this court on the jurisprudence of Article 165, Clause 4 of the Constitution, to give it considered thought, and that you return this file back to the appropriate authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matters where a question of principle arises. And of all the 3 organs of government, only one organ stands out for standing on principle, the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to admit that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest my case.
I'm a full-time lawyer, full-time. Appearing in Magistrate Court, High Court, Court of Appeal, and I appear before lawsuits for my name from time to time. What you are arguing here is a matter of law. It has absolutely nothing to do against any either individually or collectively. They are arguing this matter as a matter of principle, saying that things have not been done correctly. And because, my Lord, and my lady, Kenya is an interesting country. There is a book here, which I read from time to time. The Constitution of Kenya Commentary. The Constitution of Kenya Commentary. There is a section in this book which is very discussed. It says this. And so I gave you a to this matter. I would have been able to go through and track the particular sentence. There's a sentence which says this. Kenya is one of the most corrupt countries in the world. In this book, it's written there. Kenya is one of the most corrupt countries in the world. And my Lord and my lady, suspicions are cast on the national assembly. Suspicions are cast on the Senate. And my Lord, we appear before the record. When suspicions are cast on this court, we stand up and protest loud. All that you are arguing very respectfully. My Lord and my lady, let this matter, while I quote what my last friend has said, let this matter go back to Chief Justice. If he endorses you, he recommends you, we have no problem. She would have done her work properly. But let things be done in a proper manner so that we do not send out the wrong signals, so that we do not send out the wrong perception that there is corruption going on in National Assembly, in the Senate, and in the judiciary. Let the matter go back. Now, it was said to you that there are certain individuals who are above the law. That's not correct. When you are appearing before your lordships and my ladies, we should show that actually we are really learned in the law. All of us, as my learned friend, is to keep the phone that quite properly. All of us are under the law. The judges are taken to court. The chief justice can be taken to court. The speaker can be taken to court. The president can be taken to court. And in fact, the case of Trump versus Vance, a United States court, 9 Supreme Court judges made it very clear that the director of criminal investigations is at liberty to investigate on the President of the United States. It's my humble submission that we shall be advancing the same argument. That in this case of Gachagua, no director of criminal investigation was called or summoned to give evidence. Am I wrong, Mr. Mitchell? I'm right. I'm glad I'm still right. No director of criminal investigation was summoned to give evidence. This is a lacuna. This destroys the whole case. My Lord, there is something else I would like to say to you, very, very respectfully. Conflicts at work. We are always quarreling with people we work with. It's normal. I happen to know that Chief Justice Miller and Sir James Woods never got on very well at all. They quarreled from time to time, but they couldn't work together. I happen to know that Chief Justice Consolidation and Justice Martin were not friends. They used to throw some things against one another, but they continued to work. Some of us who have been married and so on, we know that actually at times a wife can quarrel, and at times a man can quarrel, but they still continue to live together under the same roof to make sure that the children actually have a parent, father and mother. And that's what we are saying. This nation has to survive the crisis. We cannot destroy the nation by saying because of president and deputy president quarrel. That is very, very naive way of looking at life. Thank you very much. And that I can advance to the argument of alternative dispute resolution. I put them on notice. Okay, we are advancing the notice that alternative dispute resolution. We can cricket President Recusal, we can get our Archbishop, we can get our retired Supreme Court judges to sort them out and continue to work. But we cannot abandon the Deputy Chief Justice because the two of them cannot get on well. That is a very, with respect, that's a very childish way of approaching this. Thank you. By the way, I have a hope that can donate to you. And a presidency.
I have it also.
Oh, thank you. Yes. May I say I'm very happy that your lordship reads so widely.
I always do. So Senator Council Paul Muti, are you responding?
No, also in the interest of time, I will go along with the commission.
Then we can give you 1 minute.
Just 1 minute.
Your name again?
Yes, Kimoto, Njiro, Makazi, and Tess Kimoto and Company Advocates, Kerogoya. Yes, I wish to respond just briefly on one issue. That is the issue of service. There was an issue raised that the notice was not necessary. And we insist that because today was inter-parties hearing, then the notice was necessary. We also wish to say that one can do a good thing, but at the wrong time. And the reason why we are saying this is that the Chief Justice, though we are being told, you have been given a memo and directed to the portal, which I have checked right now, and it's not there. The last thing that was there was a ruling delivered by Honorable Chief Richard Mwongo at Kerogoya, and there's nothing else. So the Kerogoya matters, they have nothing else there. And we have been told this internal memo was filed as petition E14 of 2024. So that is not true. However, we wish to say that once a court sits on Saturday, and then at a wee hours, it could look like a good thing, but then a wrong thing. Because the perception people will have is that there's something fishy going on. That is what we are crying out loud and saying it is not necessary. And the last thing that I wish to note is that justice cannot be served expeditiously while infringing the rights of others. So we are very much in order. Fair hearing is a must. And we cannot be told it's for the interest of quick delivery of justice that will infringe other people's rights. So we are saying, let us be heard fairly, and we be given enough time to respond to all the motions that are before court, and also the petitions or the responses filed, so that we cannot be prejudiced. That's all.
Your Lordship, with your very kind permission, my name is Satimpa. I just have one issue to respond, and that is by Professor Guido Mugai on, Your Lordship, Professor was so precise as to the time when the file was transferred from Gachagua. That is at 3:45 p.m. Your Lordship, I have also taken the liberty to look at the order that was issued in that matter, and it was the order was issued at 3:37 p.m. So in 8 minutes, Your Lordship, the petition E015 was transferred, or rather was transferred to the Chief Justice. Your Lordship, in our matter, that is petition E014, it was transferred to Her Ladyship on 11th of October. So those are 8 days. Your Lordship, therefore, we don't understand why the expediency that came in the sense that one petition is transferred to the CJ in 8 minutes, while our petition takes up to 8 days for it to be transferred.
I think the petition also filed in Gachagua. The lawyers who did that yourselves,
yes, Your Lordship,
should answer that question.
Your Lordship, and that's the
Yes,
issue.
that is your question to answer. You cannot pose it to us.
Your Lordship, it's in the context of the matter in which...
Yeah, you must balance all issues. You don't, when an issue favors you, you want to raise it up. When it doesn't favor you, you want to put it down.
I'm well guided.
The issue orders which came from Gachagua by your orders. Thank you very much.
Thank you.
Thank you very much. Before we make final orders, please keep quiet. Before we make final orders, we as a bench, we want to thank all counsel for the mature way in which we have conducted today's proceedings, and then the legal arguments which we have put. They are going to assist us to reach a decision which we shall render tomorrow at 3:30 p.m.
Your Lordship, perhaps before you turn off, there could be a possibility, Your Lordship, that it is imperative that we have the other files that were not before you coming up for a mention tomorrow, because there is an application for the recusal that I have filed. I would perhaps also wish to seek directions on it.
May it please the court. Once more, my name is Dr. Eboso, and I'm still beseeching the court that there are other petitions that were filed on this same matter, and which applications were made, including temporary injunctions, but which were not given, and which it would be good use of judicial time if the petitions and the applications therein were had together with the applications that are in this matter. And I would like to point out that if this bench, which is a high court, proceeded to hear the issues that surrounding the conservatory orders in this application, the 3 applications that are before this bench, absent the participation of the applicants in all those other files which have already been filed, we would suffer prejudice, because we would be arguing applications after the court has already sat, and we would be reinviting the court to argue the very same thing. So I would wish, as the court retires, to consider that. Thank you.
Okay. Maybe before the Honorable AG addresses, I just want to make this clear again. We will not deal with any file in which we have not been empaneled. If you filed a petition and it is yet to be empaneled, it is upon you as counsel to follow it up with the deputy registrar of the court. First of all, we have to ascertain whether you applied for empanelment, because it's not automatic. If an order for empanelment was made, follow it up. That is the only time you can know what happened. When the file is empaneled, comes before us, we will deal with it. For the matters which were empaneled, and maybe they are not here, we presume they are not before us because we were not moved. We have handled the matters today because we were moved by an application. If you feel we need to look into that matter expeditiously, you may have to consider. But at the appropriate time, we will issue comprehensive direction on all the matters which were empaneled with, which we were empaneled, even if there will be no applications. So let us get it clear so that as we move forward, we avoid this back and forth of getting us back to matters which were either paneled or not paneled. Let's be focused. We will deal with every matter, but now we are dealing with matters where we have been formally moved. Thank you.
Yes. My Lord, we are very kind and we do thank you for holding the flag of justice so far.
My Lordships and my lady, on behalf of the respondents, I want to thank you for according us audience this afternoon to this evening. I want to thank you for your patience. And as the teacher ahead of the class, I want to encourage my learned friends that we must continue being respectful, professional, and holding the dignity of this course very highly, and protecting the dignity of the courts and the dignity of our country. Thank you so much, and have a blessed evening.
Thank you. May I, sorry, I like talking. May I say that I am most grateful to the remarks of the Honorable Lady Attorney General. And if I may say so, with respect, in the most recent times, she has shown that the court must be respected by herself personally appearing in court. There are some previous Attorney General whose name I would not like to mention, and who are full-time officers, workers.
So we reconvene tomorrow, the 23rd of October at 3:30 p.m. Thank you.
Even you, I like that point, Okay,